all the very best. May it be a resounding success and may it be a guide for most people in the industry to help ensure follow the law. As a starting comment, as you mentioned, can we have more mics here, please? Yeah. Thank you. What was your reason and the message behind writing this book and the intended sort of message to everybody in the industry? If you can start with that. What do you want to convey with this book? And it's very timely, though.
Thank you, Burgess. As what I was just highlighting even in my welcome address, one of the most key things about writing this book for me was organizations and individuals understand the value of the data that they're dealing with. So it's very, very important that they deal with the data and handle it in the right fashion. That was the inspiration behind it.
Thank you. Sundar, there are so many compliance in this. You as Chief Risk Officer for one of the biggest brands and now the biggest brand in the country. One more compliance, but I'm sure a very timely one. Let's talk about the significance and the importance of this one so as to ensure that the overall compliances from a privacy perspective are met.
I think more than compliance, it's a very important initiative for every financial services organization. And I mean, there are so many meetings and committees and legal experts.
And one more.
And one more. No, we met on this subject. Yes, sir. Privacy. When, what, how do we deal with that? Do we wait till the rules? Do we start beforehand? Do we advertise that we are compliant? No, we don't advertise. Legally, we were instructed not to do that. Wait till the regulations come. So, and of course, lots of committees in the government where you are represented as an organization. And it is very important. So compliance, I wouldn't treat it as a compliance. For us, we have launched digital transformation journey. And being a huge organization, it's an elephant. Some would say white elephant. But
and they say elephants can dance, that's why we
yeah. And so this is an elephantine task to make policy holders aware, to make employees aware, to make vendors aware, to make all stakeholders aware of privacy requirements, digital preferences of customers, and also go through the journey of launching it through mobile, through internet, .com, pads, iPads, so many apps we have already. We're also developing super apps as part of digital transformation journey. So it is a very important element. I wouldn't say it's a compliance cost, I would say it's an investment. Investment in the transformation journey. And wherein actually to capture need of the customer is important. You say you launch digital transformation, but you don't capture the need of the customer. That is a fallacy. And therefore, it's a right step. And I think it would come as part of the journey. Obviously, at this juncture, we have not digitally transformed yet. It's an ongoing journey. Let me also clarify, I'm coming here in my personal capacity, more as a friend,
colleague and a speaker in the industry.
Correct. And so I'm not representing my organization here, but I'm aware of what's happening.
Not current, not past.
Not past. Not current.
Thanks. Thank you so much.
Just sharing my views.
Appreciate that.
Thank you.
So it's not a cost, it's an investment. And as you mentioned, capturing the voice of the customer. Urmi, over to you. What's the impact of DPDP on the trade segment? Will it bolster trade? Will it be impediment? The pros and cons?
Sure. I think cross-border flow of data is it's absolutely an indispensable part of trade today. And part of that, of course, is personal data, and the commercial use of personal data is something that can really encourage digital trade. It's something that can encourage growth, innovation. And I think India having this law, and I think the rest of the world is still kind of waiting to see what happens with the regulations coming out, and that can be viewed as an entire package, and waiting to see how that translates to companies and their compliance, and what is the element of foreign policy that you can attach it to. So is it something that India would like to negotiate some agreements on? Is it something that is more of a domestic focus? So we're all sort of watching this very exciting landscape to see how it actually translates in reality.
Thanks. And do you think this will bolster Indian trade, an opportunity for India from a perspective of data localization? Also, is not mandated. Will more companies invest clouds and scalers and AI centers here in India? Do you think this will fuel that growth?
I think what the Act is perhaps clear about is the impact of certain regulators, for example, payments data, which necessarily needs to be localized. So it would spur growth there. And I think we're still, again, UK companies and other European companies are still kind of examining the landscape. So unless and until the regulations come in place telling us exactly how the companies should comply, apart from the acts that are sort of clear in terms of regulators, we'll see what happens.
So wait and watch.
Yeah, wait and watch.
Thank you. Puneet, there are 120 countries who've got similar privacy laws. What makes India's laws different, and how? I think it's also mentioned as a she for the first time, the whole law is mentioned. So any of your views on how is this law different and more progressive?
So as a matter of fact, data is being capitalized, utilized, stored globally. However, India has a very unique position. So it's not just something which people talk of as an election propaganda. But if you see, India has been among the front-runner countries to actually implement a very balanced data protection law. So when you look at the political scenario globally, you see China, which has very stringent data laws. US, which had absolutely flexible data laws. Now they are also in the process of trying to implement something in the lines of India, for that matter of fact. So they are also trying to, look at a more balanced regulation. But they had a free nature of law, you had a very restrictive nature of law, and the rest of the world was not balanced, but somewhere oscillating between the two sides. So either the free side or the completely controlled side. So there was nothing in the middle. Apart from that, yes, you may say the EU GDPR was there, but the EU GDPR, if you see, was simply a directive. So there were ICOs formed, there were prosecutions happening. However, there was no proper form of implementation at a global level. So where there was an enforcement that, let's say, every organization dealing with EU data has to be compliant. But I'm quite certain most of you organizations would have realized how many of you have been pulled up by an ICO as yet. From 2018 to now, it's not happened. Because the implementation has not been that strong at a local level, getting local countries, getting that data, building this form of an umbrella on a global perspective. So there has been a directive, implementation is not strong. The Indian law has a data protection board, which is given abundant powers of implementation, direction, advisory, pulling up organizations, seeking their data, literally like auditing them also with respect to their data. So in that way, I would say a lot more robust mechanism is already prescribed, which a lot of previous regulations and directives lacked. They had, let's say, the content for what had to be done, but the content to actually make it implementable was not there.
So content to make it more implementable, and so balanced DP law compared to other countries, and a robust mechanism to implement that. Sundar, so many compliances. Do you have one more mic here possible? Oh, shared? Okay, great. We'll share that. I'll share mine. Is this one more compliance? Does it make the life of a CRO more tougher? Or do you use technologies and processes like unified compliance to homogenize this? How do you ensure companies implement and are compliant towards such a good, well-balanced law?
Coming back to your earlier question also, the way India has gone about this, it's very good, very consultative.
Yeah, very consultative, yes.
And ensuring that, it's proactive. So, which is good. I mean, the draft was, discussed about 6-7 years back, and then I've been in so many committees.
4 versions, right?
Yes, 4 versions of that. And this is a very practical approach, I would say. And so, what I understand is also the regulations will not be detailed, although everybody says we'll wait for the regulations. So it is going to be regulatorily driven by the regulator and the government. So this is what I understand. I may be wrong, I may be right. And so, how do we approach that is going to be tricky in that sense. Yes, it's one more compliance requirement, stringent in that sense, because of the fine. The fines look scary. And It's very, very risky to have that. It's not about even the value of the fine, it's a reputation risk also. The fact that you're fined or pulled up gets published in papers, and media, in television, so many things. So that it's a problem. It's a big reputation risk. And so how do we approach it as more technologically, digitally? And the good thing about India is digitally caught up now. And the kind of advancements in digital world and in transformation requirements, fact that LIC itself is speaking about digital transformation, BCG is dealing with that, and then there are many more consultants going to come in. It shows that government is seriously bothered about marching ahead on the digital transformation journey. And so that's the good part. And therefore, the only way to handle this is digitally. Only way to handle it is technologically. Only way to handle is to give the power to manage requirements digitally, technologically, consultatively and proactively. I also believe that at least in the first 2 years, the fines won't be much. It will be more proactive measures. I'm not sure about the time that would be given. GDPR gave 2 years time. I don't know what India is going to do. Some people say, no, we're going to straight away launch. And so I'm really worried about the regulations and the regulator.
Is worried, or are you more proactive in terms of...
We're also proactive, yes. There is a committee that was formed by their IIDAI. We've given our recommendations. I think government is going through that.
So what you're saying is India is digitally arrived, caught up now, as you mentioned, and the act was in a very nice, concerted way. Urmi, over to you. GDPR was regarded as one of the most stringent laws, right? From your perspective, do you think this is compatible, this is more stringent, or it's more lenient? Puneet mentioned well balanced, but your perspectives on that?
Sure. I think there are several similarities that you have with GDPR. I mean, the core principles are the same. So data minimization, purpose limitation of data. There are some differences. For example, categorization of data is one of the key things that perhaps is a point of concern, or perhaps we will see it develop in the future. Again, everything is open to kind of development here in this space. But just in terms of how you would classify sensitive data, what are the security provisions around it? And even the development of the Data Protection Board, how accountable is it? So there are certain things that are there to watch out for as we see the space evolve, and it depends what India wants to do with this law as well. Does it want to? And
what do you think India wants to really do with that?
I mean, it's not my place at all to say that.
If you can ask Puneet that question. Puneet, what does India really want to do with this?
And I think just to add to that, I mean, whether it wants data adequacy, does it, does it want the Osaka track of discussions to proceed? So it's all a very sovereign space for India to kind of, figure out how it wants to approach other countries, how it wants to approach the GDPR.
I'll come back to you on there's a negative list is going to come out, but it'll come back to you. The board, Puneet, the board's going to have the supreme power to talk to me about the constitution of the board, its powers, its remits. Sundar hopes it's not going to be, the first 2 years will not be fines. But what's your thoughts?
See, as a matter of fact, this has been in deliberation for years now, the act itself, in multiple draft stages. So if you would see in any other country in the world, you wouldn't see so much of deliberation and discussion. We are a true democracy. We have proposition, opposition, lots of opposition, even right now opposition and proposition. So with the amount of opposition that any legislation goes through in India, that's a lot of scrutinization, which again, even with the rules, there have been multiple drafts. So to a great extent, the act has been enacted already, it has been a year to it. So to think that there would be a lot of leeway given to organizations at a later stage, that is a bit questionable, because there has been a year's time already provided with respect to compliance. The act was already there, so organizations knew it. So the rules don't change the provisions of the act. The rules only mention how a consent manager will be empaneled, exactly, you know, what the formulas on the application of the penalties would be. These are the grounds on which, you know, very clearly even our IT minister has very clearly made it, you know, public, that the rules are not in any way going to modify the Act. They're simply going to supplement it with respect to procedural compliance. So which means the Act compliance is any which case what is required. So a lot of organizations tend to think it's only when the board will be formed that we may be prosecuted, or, you know, when the rules come out, we'll come to know what to do. What to do, you already know in the Act. Now, exactly, you know, what the empanelment process of a data auditor would be, what of a consent manager would be, those procedural aspects, unless you're aspiring to become a data auditor or a consent manager, it may not change too much for you to that extent. Now, with respect to the board constitution, that is also already specified in the Act. So as a matter of fact, prior to the elections also, it was quite a much thing in the news that the board was to be formed. However, due to certain priorities changing the rules, the board, everything was postponed to post-elections. So it was quite public information which was available. So with the board constitution, yes, the hearings start. Now that doesn't mean that the board is absolute. From the board also there is appeal provisions which are there, where an order of the board can also be appealed against. The nature of the board is very senior. The hearings, etc., the powers of the civil procedure code which are accorded, they have the power to summon documents, they have the powers to go about examining witnesses. So almost like a judicial proceeding which is going to happen before the board. So you need to understand that this is not something like a regulatory body or a regulatory representation. This is going to be in the nature of a proper litigation.
Okay. I like the way you mentioned proposition, opposition, true democracy, and rules don't change the position of the Act, it just supplements it with procedural compliances. From your perspective, will there be lots of litigation, will there be lots of fines, or will there be a period of 6 months, 1 year, 2 years was given by GDPR? What's the period, 6 months?
See, as a matter of fact, if you're aware, Chandrasekhar ji has already gone ahead and made declarations that big tech companies are going to be expected to comply right outset. Because if you're already GDPR compliant as what you claim globally, then there's no reason why you would not be able to easily comply with the
Like the
Indian
word as
law.
you claim, Logan.
Yes.
Claim emphasis.
So then in that situation, why do you require extra time? With respect to small scale and medium scale, it has already been publicly announced that there would be some time which would be given. How much, that clarification will only come with the rules. That, you know, what would be the staggered implementation with respect to medium and small scale enterprises. So all of them would definitely come within the fold, but the timeline that will be provided for the same will be informed then.
And the exceptions, who would come? Would startups come on the exceptions? Would there be exceptions to this law? Would there be any exceptions like startups which may or may not come?
No, there's no exceptions for startups. So any organization dealing with data, the Act is very, very clear about that. So that you may be a startup or that you don't have funding or you're bootstrapped, that's not a ground that, you know, your data can be misused. As a matter of fact, a large number of mishaps of data are happening in startups. So you have fintech startups, you have a lot of organizations in the tech space which are startups, and unfortunately they invest money in marketing, they invest money in everything else, but they don't invest money in cybersecurity or data security. And they are the open points. So if you know, many of you would have read about the major payment gateway frauds that have happened in the last 6 months. So many times in all these fintech companies and payment gateways, from my experience, I can tell you, there are multiple integrations with startups in the middle. So a lot of these financial frauds that you're seeing are emanating from those small integrations of the startup. So though, let's say the payment platform says I'm PCI DSS compliant, I have everything else in compliance, but what about your vendors who are not financially capable to be compliant, and they are the loose links everywhere in the picture. So in fintech space, in technological space, a lot of these things, one of the most key issues is this.
Sundar, what's the effect of this on insurance companies? Will it bolster the insurance industry? Will every company now go and seek cyber insurance?
I think before that, I would like to answer the question that you asked.
You always ask one minus question.
No, I
like
listened to
that.
what you're saying. Administratively, legally, yes, I think she's right. Everything is set.
Oh, you're going against her on the book panel.
I'm not saying against her, just slight in
Contradictory.
terms of time.
Okay.
No, you need to do
you want more time.
technologically enablement of all this,
Sure.
or digital enablement, and that takes time. in a large company, especially financial services company. All these digital investments take up a lot of time. So you would need to embody applications integrating various applications. Communications have to be embodied. SMS messages have to go to stakeholders. Internet messages have to go. Emails have to go. And so there's a lot of stuff, a lot of technological advancements that need to be done. Now, question is, why don't the companies do that right away? Why are they waiting for the rules to come? That's a correct question. I agree with her on that. Yeah, all that technological advancements.
Don't need to wait anymore, right?
So, but people are waiting, unfortunately. Industry says, no, we'll wait.
Puneet, people are
wait
really
for the
waiting,
regulations.
or some companies are, how much percent are really seeing proactive? I will not wait for the rules. 50% would have got compliant by now? The large ones at least?
No, about 20% or so have actually started exploring, started basic data security, cyber security, which till now they never ever perceived as a risk.
Correct.
So as a matter of fact, I would say maybe banks, insurance companies like Sundar coming from that background, they already were regulated to some extent because of the regulators, RBI and IRDA.
Sure.
So to some extent, they had a certain level of preparation. Whereas a large number of organizations, if they are not from the regulated sector, so they may be not startups, they would be you could say good turnover organizations, but because they are unregulated, not in the regulated sectors, they haven't even had basic cybersecurity or data security. So organizations are just about coming to that level. We are talking about actual compliance with the DPDP Act, which I think is still a journey for most organizations.
So on the insurance part, will more companies take insurance?
So my whole point was that the journey would take time, and
course
therefore,
it'll take time.
therefore the regulator needs to give time, at least a year. GDPR gave 2 years, but I don't know how much time would
So
be
your
given.
request, your ask is?
Request or
taking
ask
time.
is that, but I don't know whether the government would relent.
I'm sure they
because the pronouncements are different platforms.
I think the message is to be serious and do it ASAP.
Yeah, that's right.
Urmi, there are opportunities here for bolstering trade with the consent manager. Do we think more companies would get together and say, okay, can we offer new tech services like consent manager platforms? Do you see that happening more? Would India-UK collaboration increase from that perspective?
I think in terms of collaboration, there's a lot of conversations to be had with the regulator once it comes into being. So that's the Data Protection Board and the ICO. I think that could be a greater cooperation between them, and figuring out compatibility between the two laws would be the way to go for companies which are stationed here and would be compliant with the laws. In terms of investments in new technology, I think that's probably inevitable for companies which have to comply. And we could possibly see a lot of growth there in terms of technology dissemination, as well as learning more, in dissemination of these skills, as well as technologies coming from other countries.
And the people part, do you think a lot of upskilling is required, or do we have the right skills already?
I think there's no, very diplomatic answer would be there's no end to how much we can develop on this front.
Is there a dearth, Puneet? Was there a dearth in number of people with the right skills to be able to help implement DPD compliance?
Yes, there is. So as a matter of fact, people are starting to learn the subject now. But will theoretical learning help in practical implementation is a very different question altogether. So learning the subject, getting yourself certified, maybe that's the first step to theoretical knowledge. But the practical aspects of it are something which a large number of organizations are yet to explore, individuals are yet to explore. So the professional skill set development and the ecosystem development is yet to happen in India.
So as a follow-on question, as you mentioned, will theoretical learning help in practical implementation? What is the most toughest thing required to implement this law? What will be the most difficult for companies?
The most difficult question out here that I'll tell you is the penalties are up to 20 crores or to 200 crores, up to 20 crores for certain offenses, up to 150 crores for certain offenses. This word up to. So here what's going to end up happening is that you are required to demonstrate your compliance in legal procedure, in a litigation procedure, which will mean that everything is examined, cross-examined, questioned, and in that entire aspect, when all of this comes into the picture, the question of up to is going to be quite challenging on how you're going to go about genuinely demonstrating your compliance. That's going to be the major challenge.
So demonstrating compliance would be tough, and that adequate security law, controls will be tough. Krish, back to you.
I didn't answer your
Sure.
cyber insurance
I'm
question.
waiting for that.
And insurance companies. So there is a background to this. Way back in 2013, there was a fraud prevention regulation. So based on that, we set up a body to share data and secure it, again, keep it confidential and utilize the data. Because many times fraudsters tap 3-4 companies. They are not restricted to one company. And so if you share data, you are able to prevent fraud. And so when you come to DPDP compliance, you need to seek consent of your policyholder beforehand to share data. And so we've done in a very aforesaid manner in the proposal form or application form put clauses and which the shareholder, which the policyholder has signed off. But the compliance requirement of DPDP is more severe, more exhaustive. You need to have a separate concern management system and navigator system. We need to identify various systems that share data. We need to trace the data journey, origin of data, whether bought or created, how is the data made, maturity of the data, how is the data dispensed with. Now customers might demand partial destruction of data, full destruction of data, semi-destruction of data, or keep the data. We'll have to determine that through systems. There are regulations which say you can't delete the data, you have to keep the data. Like for instance, Prevention of Money Laundering Act and Anti-Money Laundering Act requires KYC records to be kept 10 years after the maturity of a policy. Now if a customer says destroy my data, how do I deal with that? Do I destroy his data or do I deal with the regulation? Which regulation shall prevail? Will the PMLA prevail or the DPDP Act prevail? There are challenges. And so the technology also has to be enabled to deal with these challenges. Once the challenges are known, how do you know the solution to the challenge? So all that needs tremendous investment of time, money, consultation,
you made your point about time.
committee.
But I'll come to you on something called PET, right? Prevency Enhancing Technologies. But back to Puneet. Puneet, will this be conflicting compliance or conflicting regulations where maybe a few industries mandate data to be kept and maybe front-end data can be removed? There are ways of going around that. But how will companies sort of go around that? And to follow up with you on the PET technologies.
So as a matter of fact, there are multiple laws in India that require data to be retained for a certain number of years. So tax laws, employment laws, PMLA. So there are multiple laws. So yes, an organization, when they do the data mapping, will also have to have a clear understanding, because the Act provides you need to delete data only in the situation. So let's say the right to be forgotten, the right to erasure can be exercised subject to the provisions of other laws. So where any other law is mandating that the data has to be preserved for a particular duration, the organization cannot delete. So which means the organization needs to have a prior robust mechanism to identify those different data sets which cannot be deleted, the reasonings why they cannot be deleted. So if a data request comes from a data subject, they should be able to even respond suitably to the data subject as to why they are unable to delete the data and under which legal provisions they are going ahead to retain that data.
Would mean there's a negative list where we may not be allowed to send data to some countries. Would that be linked to the trade list in any way? Do you have a list of countries already negatived which you think will follow through? If yes, which countries are those?
I mean, I think we're all dreading whether we're on that negative list or not. But you know how this works with GDPR is, of course, completely different. With GDPR, there's the whitelisting approach, excuse me. And where, I'm sure you're all aware, through standard contractual clauses or through BCRs, you transfer data outside the European economic area. And so this is new. This is India mandating perhaps a couple of countries which it cannot share data with. And I think countries like the UK, countries in the EU are kind of waiting to see what that procedure will be like. So what is the basis on which they're going to do that?
And will a company, if it's already having other business in that country, would they be given some time to cut off if they have data there, or?
I mean, this is completely something that is open to.
There's a list like
yeah.
that exists right now where India cannot do trade, forget data exchange.
No, I don't. To my knowledge, there isn't.
So would it
but
be the first of its kind, Puneet? Would a negative list be the first of its kind? Any other country in the world has a negative list like that?
Well, yes, a lot of countries like the US and UK do, but they don't call it a negative list. So even whether it may be with respect to data, whether it may be with respect to business, yeah, it's called sanctions. So it's not given the terminology of a negative list. India has not really had this kind of active sanctioning policy unless there has been any situation of war with a country. Sure. Then too, there hasn't been that active, the way you see the West doing
Completely.
it, we don't really see India doing it. But yeah, this is the first time.
And that's quite positive, right?
That's quite positive.
Right,
that's
Ruby?
quite positive.
Yeah.
But yes, the Act does mention that there would be a listing which would happen of the different countries to which, if sensitive data, let's say banking information, geolocation information. So basically, certain categories of data will not be allowed to be transferred to certain countries. That list will be coming in soon also. So then you cannot say there's an absolute data localization, but yes, wherein there are certain sensitive countries where potential misuse of data can happen, then in that situation, these steps would be
Some of those laws, like telecom, already you cannot send telecom subscriber data
Yes.
outside India, except for roaming customers.
Yes.
So those laws already exist.
So for a lot more data sets. So right now we are only talking about telecom. What about other data sets, like let's say today an insurance company, they are having data, like let's say there's an international insurance company tying up with an Indian insurance company, and there is data which is dealing with the locations of individuals, their medical health conditions. So a lot of this data, can it be shared with a partner organization in a country, let's say where there is a so-called sanction also by the Indian government? Can this data be shared there or not? So a lot of international trade, mergers, acquisitions, a lot of these things will also eventually get determined by which country can those data sets be sent to.
Thanks. Back to you, if you can answer my first question. Will insurance companies, maybe the gentleman there from insurance, do you see a lot of insurance coming up, business picking up? Yeah, he's very helpful with that.
Yeah. So you asked about cyber insurance also. It is very complex now.
There are more companies going for it because of the law?
There would be, but cyber insurance is not supposed to protect non-compliance. So if companies are negligent, non-compliant, then you will not get the insurance claim. But then
how does one prove that?
the journey is very complex because it's not necessarily non-compliant. You have dependencies, vendor dependencies, employee dependencies, structural dependencies. And then if there are uncontrollable factors also. So if there are problems there, those things could be insured, cyber insured. And so there would be a lot of business opportunities there, and it's going to be really exciting. How do you venture out to this area? But I see tremendous increase in business based on my own international exposure when I was in the previous company. So there would be an increase in cyber insurance.
Sure. And your views on PET technologies, privacy enhancing technologies like data discovery tools, data classification tools, do you see a lot of intake from that coming in?
Yes, tremendous. So there would be inventorization requirement, data navigation requirement, there would be a tool required to project manage all this, there would be a tool required for DIRM, which is the insurance risk, the information risk management of
tools.
Digital management tools. So you would need several tools because there is no single tool. And so you need to integrate, and the integration measures are faster these days thanks to middle layer being robust. So there would be several technological investments done by companies thanks to DPDPA. That's why I said you need time. You need a journey, you need time, you need project.
It. I'm sure police heard
Everybody is
it,
waiting. So
but she can.
it's all happening right now in the financial services world. Everybody is going through this journey.
Why only FS? I'm
Even
sure all companies.
telecom, all companies, pharma,
Any sector,
telecom.
Any sector which will get more affected, especially with the SDF category. Do you think pharma is definitely SDF? Or healthcare will
I
definitely
think almost every organization today is dealing with sensitive data. So our Indian law does not bifurcate sensitive data and personal data. So any data that is classifying you as you is classified as sensitive enough to come within the ambit of the Act. So then in that situation, it's not just that you're looking at hospital data or you're looking at pharma data. So the definition of sensitive personal data was something which was there in the SPDI rules earlier. Now those have been obviously set aside, and what we are talking about in the Act is personally identifiable information. Any data set that identifies you as you, that's sensitive enough, because together mapped and together it can expose you to a lot of other risks. So every organization dealing with data today is actually coming in the ambit.
So then who will be a significant data fiduciary? Would it be definitely a set of companies or only the volume of data?
Large scale volume of data
It
processing.
could be a small company handling
It could
data
still be a
of-
significant data fiduciary.
So would there be numbers? Would there be classification of industries?
Yes.
Would a whole industry like pharma come under that?
Yes, to a great extent. So significant data fiduciaries would be any organization having large-scale data processing, large-scale volume of data processing of personally identifiable information. So it's not about the size of your organization, that you're a startup or you're a bigger organization. It's about the nature of data, the volume of data that you're processing. So eventually you may not be a Facebook, but that does not mean that they are going to be significant data fiduciaries and you will not. If you are processing data to that magnitude, you will also be.
And the question which normally gets asked, the law got released in August 11, 2023, and when the rules come out, will there be retrospective? Will companies need to be compliant from August 11, 2023, or will they be after the rules come out?
See, that's a basic principle of law. As a matter of fact, our chief guest here, he's also going to throw a lot of light on the provisions of the Act, Justice Gautam Patel, who's already here, that the law has one basic principle: it cannot be retrospective in nature. So that's one of the things. If a law is implemented retrospective, it is challenged multiple times in litigation, and you cannot have a retrospective liability and penalty being imposed. So yes, if the Act is already enacted, then you cannot call it retrospective. This was already enacted last year. But yes, there was no board at that point of time to prosecute.
I just thought I would answer that. So we did receive show cause notices
Already?
in August 23. And not show cause.
What August?
Explanation.
In a few days of the law coming out, you
yes,
release.
so
Okay.
one
You
of
see
the
this trend, Puneet?
training
You see-
vendor,
okay.
one of the training vendors' data was hacked, and it was published. It went into the dark web also, and then a regulator got hold of that and then said, "What are people are up to? Why is the data not kept confidential?" Then we said, "No, data is kept confidential. These are only employees who attended training there." And only names of those employees who attended training has
holy
been
names.
published, and we've taken measures to take actions against the training vendor. And then training vendor also met us and said, we'll put this impediments and ensure data is confidential. So it's already a problem. It's not that you have to wait for the
Already
regulation.
an opportunity or a problem, which
Yeah.
is you see it. Urmi, do you think startups play a big part, especially in the PET technologies, for privacy enhancing data scanning, data discovery, data localization, measures to check? Do you think startups are coming up in this space? I mean, there are other startups in India in cyber, but do you see India coming more on the PET technologies in startup space?
So I wouldn't be an expert at all on this, but I think as far as the UK has been concerned in this space, has always been actively trying to collaborate with startups in this space for better adoption of these technologies. Some of the agreements that we have, overarching partnerships, try to enable skills transfer as well as focus on future technologies as we progress. So there's a lot of scope for international collaboration when it comes to these technologies, and we're always here to kind of enable that startup ecosystem in India.
Answer your question, yes. So one of the organizations that shares the insurance industry data, recently they were planning to make it profitable organization, but after the act, I don't know whether that's the reason, they said, no, we'll be a no profit body. So they will seek exemption from the regulators and the government to share data. And the problem that is there is the consent management. Now, before August 11, 23, all those people whose data you have, do you seek retrospective consent, historical consent? Like when PMLA was formed and whenever it was, we did seek that. And then, of course, everybody never consented. You write letters, you write emails, you send SMSs, but people don't give their formal consent. how do you deal with that data? And there are challenges. So do you do grandfathering of earlier? You can't, because consent is to be sought even beforehand. At least GDPR experiences taught us that. So you would have challenges of all these kinds, and therefore some bodies need to be exempted from application of DPDP because they are doing service. So that's the point.
From your perspective, would just a notice be enough for past data, or would you need some form of, how does handle past data? Grandfathering
So
or
past
approach?
data, the law is very clear that you may not have to take consent again, but yes, you have to give the option to the individual to withdraw the consent.
Okay.
So those particular notifications have to be sent to them if they wish to withdraw consent. If they withdraw consent, then yes, you will have to stop processing their data completely. So that is there. Yes.
Okay. We've done 45 minutes. Last closing remarks, Suna, starting from you to last quick 30 seconds of closing
So I
remarks.
think the very exciting journey and complex journey are on float.
Exciting but complex. Okay.
And lots of digital transformation would happen. A lot of technology companies would have good business in the next 2 years because of all these requirements. And of course, there will be knowledge transfer from abroad, especially GDPR compliant companies. And those technology companies which help GDPR compliance would be also coming to India in a big way, if they have not already come. And so there is a lot of
And also bolster a lot of people to get good jobs and good skills.
of course,
that
of
industry
course.
is doing.
Lot of that training, certifications.
India being the capital of the back office centers and the IT.
No doubt on that,
You could
no
do
doubt.
security and privacy as a big.
I've already met many organizations which have formal training courses on GDPR, privacy, DPDP, and so on. So
Whole industry gets burned, right?
yes.
Thanks. Urmi, over to you. Your closing comments?
I think the whole world is kind of looking at this space in India. India being one of the forerunners of digital technologies and enabling emerging technologies as well. And all of it, and the center of cornerstone of all of it, is a strong data protection law. And I think all countries are also looking forward to, especially I can speak for the UK and EU, they're all looking forward to partnerships and collaboration in order to make this enable easier cross-border transfer of data. So this is a very exciting space, especially so for
Exciting
trade.
space, more business partnerships and collaborations for trade. Great.
Absolutely.
Puneet, your closing comments? And
Well,
I have one more
really-
question after that for you.
I really liked when Urmi said that, from the British High Commission perspective, UK globally, the whole world is looking at what India does with the Data Protection Act. So I think that puts a lot of onus and responsibility upon the entire system in India, whether it may be the organizations, individuals, the judicial systems, the law enforcement, in order to, show to the world that, yes, we are going to enact an act, we are going to implement it, and the whole way ahead for the world to see. Because today there isn't such a balanced legislation anywhere in the world. So there is, like in Singapore, there is a piecemeal legislation. You have a very restrictive legislation in China. You have an open system in the United States. So I think this is a great opportunity wherein we can show the world how a balanced legislation to some extent. There are many loopholes in the law also, even in the DPDP Act, which I think would be subsequently amended also. But how still a balanced legislation can spawn business, can spawn opportunities and the development of an entire ecosystem in the country.
So takeaway is such a balanced legislation which can make India stand out. One more question. Your next book, what will it be on?
So mostly it would be
what
on...
will you invite us again to speak on?
Yes, so mostly it would end up becoming on the mandates that the rules would put forth. So in this book itself, there would be a barcode where you can
mentioned
download the
barcode to
rules.
get
Yes,
the
you
rules,
can
yeah.
download the rules.
Would you also have your views on the rules and your interpretation?
Yes, there would be
FAQs?
short views, but the detailed views with respect to that, there would be
Second book.
the next book.
And FAQs on that. Great. With due respect and good luck to you for the second book. All the very best. Thank you. I enjoyed doing the moderation and great fun and great discussion. Thank you so much.
Thank you very much.